Thank you, Mr. Chairman. Judge Wise, you're not being honest with us, are you?
That is incorrect.
Well, we all may be poorer under President Biden, but we're not stupid. We have a long list of your articles and your opinions and your political statements. On March 8, 2017, you wrote an article for Time magazine while you were a sitting judge. It's entitled, Judge, Gender Laws Are at Odds with Science. I'm going to quote your words. When legislators blur the lines of church and state and enact laws that permit or prohibit conduct based on biological gender as only male or female, they place an impossible burden on the judiciary. End quote. Did I read that accurately?
I do not know because I don't have the article in front of me.
Well, I do. You also said in that article, quote, your words, not mine, sex has countless natural permutations, end quote. Did I read that correctly?
I believe that is consistent with medical science and under the Daubert standard, the science that comes in as expert testimony in trials.
On October 13, 2020, while you were serving as a state judge, you wrote an article for The Atlantic entitled, quote, your words, not mine, America's judiciary doesn't look like America. And you criticized this committee and President Trump for his judicial nominees. You said, quote, these are your words, not mine. The judiciary crafted over the past 4 years does not look like America. Not one of these judges is black, and more than 90% were raised or currently identify as Christians. I don't know how you knew that. And then you say, quote, your words, not mine. Identity is the lens that filters everything and everyone we encounter, end quote. Did I read that correctly?
Again, I don't know because I don't have the article in front of me.
I do. I got it right here. You wrote another article on July 31, 2020 for the San Francisco Daily Journal, in which you advocate for the right of sitting judges to be able to go to protests, didn't you?
That is incorrect.
No, it's not. I'm looking at it right here. This is what you say. No judge should be ethical. Your words, not mine. You just said you didn't say them. You turned these articles over. No judge should be ethically constrained from speaking or taking action that reinforces that constitutional and moral imperative. May judges participate in demonstrations that denounce racism, support equal justice, and reinforce our constitutional rights to free speech and peaceable assembly? Yes. End quote. Did I read that correctly?
I don't know because I don't have the article in front of me.
If you're a federal judge, are you going to go to protests?
I would like to answer the substance of the underlying question that was asked.
I'd like you to answer my question. I've only got another minute or so. If you're a federal, let me put it another way. Have you ever gone to a protest, a public protest, while you're a sitting judge?
Senator Kennedy, the article that you are referring to,
have you ever gone to a protest while you're a sitting judge?
I do not believe that I have ever attended a protest as a sitting judge, or perhaps ever in my life.
And you talk about Girls Inc. You say you've never heard of them. You were on the, or you don't know that much about them. You were on the board from 2014 to 2024. You're still on their board, aren't you?
I'm not. My term expired this last month.
And you've given them over $50,000, haven't you?
I do not believe that is correct.
That's what your report says. And this is the same Girls Inc. that says, quote, on its website, here's how they define girls. Quote, girls refers to gender expansive youth, cis girls, trans girls, non-binary youth, gender and non-conforming youth, genderqueer youth, and any girl-identified youth. Did I read that correctly?
I don't know. I've never heard of that policy or that definition from Girls Inc.
Listen, in spite of your, can I just have 30 more seconds? In spite of your strongly held political beliefs, and we've got all of them, all your articles, they're as long as King Kong's are you telling us today, do you believe that you will not allow your strongly held political beliefs to influence your judicial opinions? Do you believe that?
The best evidence of the type of federal judge I will be,
yes,
the type of judge.
Do you believe that?
It's the type of judge I have been for 10 years, who is one who always puts the law above my personal.
Do you also believe in Bigfoot? Do you believe in the Tooth Fairy?
Your time has expired, Senator.
Do you believe Jimmy Hoffa died of natural causes?
Senator Hirono.
Thank you, Senator Kennedy. Thank you, Mr. Chairman. Congratulations to all the nominees. Thanks for being here. Judge Wise, let me just start with you. So as I understand it, you don't think that there really is any clear-cut distinction between male and female as biological categories. Is that correct?
That is not correct.
That's what you wrote.
Sorry, that is not correct.
Well, that's what you wrote. Look, I'm reading your article, your Time Magazine article. Just to be clear, you wrote this while you were a sitting judge, 2017? You were on the bench?
That is correct, after a case I had.
Right. So, interesting choice to be writing opinion pieces about your cases, but in any event, you say that controversial pieces of legislation enacted in the last 2 decades rely on a clear-cut interpretation of sex, what I just asked you, but you say that that's wrong. In fact, gender is an intricate continuum and not 2 tidy boxes. That's what you say. So have you changed your opinion? You just gave me a different answer.
I believe that, generally speaking, there are 2 sexes, male and female, that are designated by a doctor at birth, and that applies to the vast majority of people.
But that laws that are based on that distinction are impermissible. That's what you say in this article. Is that correct? That's still your view?
That is not what I say.
Really? You say that if there is, for instance, a law that requires a distinction between male and female in bathrooms, that the judges cannot apply that law with any consistency, can't apply it consistent with equal protection. There are no, what is it? It's virtually impossible for judges to consistently apply a law that permits or prohibits conduct based on whether someone is a man or a woman. So all bathroom laws that require biological sex, that designate bathrooms based on biological sex, are impermissible?
That is not the position that I took in the article.
That's what it says. It's impossible for judges to consistently apply a law that permits or prohibits conduct based on whether someone is a man or a woman. And you specifically cite bathroom laws as an example of this. In fact, you criticize the then Trump administration's designation of gender-based bathrooms. Right? Sounds like you made up your mind on a lot of things, but I just want to get clear on this because this is an important issue, certainly to people in my state.
It's a very important issue.
You think that bathroom designation, same with locker rooms, I guess, girls' locker rooms impermissible? Biological men have to be permitted into girls' locker rooms?
That is absolutely not what I said in my
That is
article.
absolutely the import and the takeaway of your piece. You suggest at least 3 different constitutional problems with any gender-based laws, including specifically bathroom laws. You write about it. Equal protection violation, due process, void for vagueness. I was making a list as I was reading through You say that our biological variability means that a two-bathroom, even two-sex-based approach is inadequate. Judges cannot apply it. So if Title IX is interpreted to protect women's sports, biological women playing sports with other biological women, it's unconstitutional?
Senator.
That's a yes or no.
I was referring to the 5 babies born a day that doctors have challenges.
No, you wrote an article that is extremely broad that pronounces on a range of issues and pronounces quite definitively. What's this comment at the end of your article about the fact that judges must see the world through a secular lens, and when legislators blur the lines of church and state to enact laws that permit or prohibit conduct based on biological gender as only male or female, they place an impossible burden on the judiciary? What's that mean? That distinctions between male and female are a violation of church and state?
Judges have to be able to administer these laws if the direction, and I have to tell you, I work really hard to get it right, to do exactly what Congress tells me to do and the legislature tells me to do. And as a result, if a doctor finds it difficult to identify at the moment of birth for certain children.
Is a law that distinguishes between male and female a violation of church and state? You say when legislators blur the lines of church and state and enact laws that permit or prohibit conduct based on biological gender as only male and female, they place an impossible burden on the judiciary. So this is a First Amendment violation?
If what you are telling judges is that in order
I'm not telling you anything. I'm reading you your comments, and I am asking you if you are still committed to these, and it sounds like you are. I have to tell you, I think these positions are insane. I think the idea that laws based on the distinction between male and female are a violation of church and state is insane. Totally insane. I think the idea that laws that would say women's locker rooms are protected from biological men, that those are impermissible, that's insane. But that's what you say in this article. You're going to have to recuse yourself in a lot of cases, aren't you? Will you recuse in every case involving biological sex, if you are confirmed?
Senator, respectfully, that is not what the article says.
You have pronounced on all of these issues. Will you recuse yourself in any case involving Title IX, biological sex, challenges to locker rooms, girls' sports, bathroom bills? All of those things are covered in this article that you wrote while you were a sitting judge. Don't you think that was impermissible? Will you recuse? Let's get an answer to that.
Senator, your time is expired.
Will you recuse?
I did not take a position as to those issues that you have raised.
You took a position on all of these things, and your position is insane, totally insane. I will absolutely not vote for you. There's not a world in which I could support you. I can't believe you have been nominated. And if you are confirmed, which I hope will not happen, you absolutely must recuse across all of these cases or stand in violation of the Code of Judicial Conduct. I'm shocked you're sitting here today.
Judge Weiss, you were unable to complete several answers. I'll give you that opportunity now.
Thank you. The thesis of the article, which begins right after the introductory material, that is the first sentence of the third paragraph, makes it absolutely clear that my article had nothing to do with people who are transgendered or gay. It dealt with a narrow issue about babies who are born where doctors are challenged making a determination about sex. And as a sitting judge who has to administer potentially laws where I would have to make such a determination that doctors sometimes find it difficult to do, I think it is critically important. It's important under the Constitution. It's an obligation that we have to treat everyone to have equal protection under law. It is the words that is listed above the entrance to the United States Supreme Court. I actually believe that everybody who is in here cares about all newborn babies and what the circumstances are for all of them. And for those children who eventually become adults, I believe that the legislatures and Congress need to help judges and give clear indication about what to do in
I'm
those.
appreciative that you're trying to do your job with compassion. I don't think any of this is easy, and I think everybody that's involved in border security is having a very difficult time. I had the opportunity to go down to the Arizona border with Governor Ducey, and when I went, what actually shocked me was we did an aerial tour, and they had the wall, and you've heard all the stories. Senator Langford brought it up, that they just didn't put up the gates. They just stopped. I mean, you can't, if you talk to people around the country, they look at that and say, why would that happen? And then, what a lot of people said, we need to use new technology. They had the lights and cameras up, and you talk to Border Patrol, they just didn't electrify it. It just stopped. Just as soon as, right after January 20th, it just stopped. I mean, it just doesn't, when you look at this, you say, there's no logic to this, right? And I know we want to be a compassionate country, and we are a compassionate country, but we also have drugs come across our border. We have people that do, we have sometimes criminals come across the border, and we have wonderful people that want to come here and live our dreams. So when you and I talked before your confirmation, one thing you committed to me is you are always going to enforce the law. Do you believe that you and your agency are enforcing the existing immigration laws?
Yes, we are.
Right. And there's none that you have any concern are not being enforced?
I believe that we are enforcing the laws in a smart and effective way, and actually we will do so smarter and more effectively as the days and weeks progress, and I'm very focused on that, and I'm looking forward to actually meeting with the ICE workforce in the coming days to hear from them as frontline personnel, to learn of their experiences, to inform the guidelines that I intend to promulgate.
So you've seen this chart. I mean, the unbelievable increase in apprehensions, and also the chart that showed how many unaccompanied minors. Are you disappointed that President Biden and Vice President Harris have not taken the time to come to the border to see firsthand what a lot of us have seen, that there's clearly a crisis that we have to, and you've said there are things we have to address. Are you disappointed that President Biden and Vice President Harris have not taken the time to come to the border?
Absolutely not. What the President and the Vice President have done is directed me to address the challenges at the border, which are within my responsibility as the Secretary of Homeland Security, and I have visited the border on multiple occasions thus far.
As I've talked to sheriffs in Florida, what they're seeing since Joe Biden's inauguration is an unbelievable increase in fentanyl coming into Florida. And the only thing they can say is it's coming across the border. So according to CBP data, drug seizures are down significantly this year. Do you think the record low drug seizures are because our CBP agents and the resources are being diverted to manage the humanitarian crisis at the southern border?
No, our interdiction efforts continue effectively. Senator, we have a multi-tiered approach to the interdiction of drugs, contraband, and dangerous individuals. We take great pride in the capabilities of the men and women of the United States Border Patrol, and quite frankly, in the actions that I have taken. We launched Operation Sentinel to elevate and accelerate those actions. And as Senator Portman well knows, I overcame delays that preceded me in the promulgation of critical regulations to effect the STOP Act, which was a tremendous tool for law enforcement.
Why would seizures be down then? If all that's happening, why are seizures? I mean, it's the data that's coming out of the administration.
Senator, I'd like to review the data that you have and exchange data, because our interdiction efforts are quite effective, and regrettably, we are interdicting a great deal of contraband that predominantly does not come in between the ports of entry, historically has come through the ports of entry in hidden compartments of vehicles. Our technology is tremendous, and the traffickers also use air assets, marine assets that we are interdicting as well.
Sure. Does DHS feel like it has a duty to remove illegal aliens convicted of serious crimes like sexually assaulting a child or manufacturing illegal drugs?
Yes.
And is that happening?
Yes.
Okay. Can you commit that those individuals that are being released for future court dates, like you talked about earlier, are clearly going to be deported if their asylum claims are rejected?
I'm sorry, can you repeat the question?
So if somebody's come in and they've been released, all right, but their asylum claim is rejected, are they clearly going to be deported?
They are subject to removal, yes.
Are they going to be?
As far as I know, yes.
And do you think it's happening now?
I believe so. What I think we need to focus on, quite frankly, Senator, and this is something I spoke to earlier, is addressing the asylum system and strengthening and improving it, so individuals who are actually eligible for relief and deserving of relief receive it in a reasonable period of time, and those who do not, the adjudications are delivered in a reasonable period of time, which is a problem that has plagued the asylum system for years and years and years.
So going back to the wall and the technology that's not being connected to electricity, why is that?
So, Senator, we approach this in a very methodical and reasonable fashion, in my opinion, which is the border wall in many respects was not the most effective use of taxpayer dollars to secure the border. The paradigm that had bipartisan support, certainly when I served as a deputy secretary, was a paradigm of different types of assets brought to meet the challenge. Physical barriers that were in existence, the use of technology and harnessing innovation to really be force multipliers, as well as, of course, the brave men and heroic men and women of the United States Border Patrol. And it is that three-part effort that is most effective. And so the methodology that was designed and is being implemented is, let's put a pause on the construction of the border wall. Let's assess what is actually needed to be completed. For example, the levees and the road erosion that we, in fact, have committed to. And let's take a look and see what does deserve and need to be continued and what really should be stopped. And so we're taking a look at the gates, the gaps, the deployment of sensors in those parts that have been completed, and what is reasonable to complete in the judicious exercise of taxpayer dollars. And so that's what we're doing.
It sounds really good, you know, just from looking from the outside, it looks sort of crazy. The money's been committed, the wall's up, the gates just to go up. Or the lights and the cameras are all there and just not, I mean, it just doesn't seem logical to the American public.
I respectfully disagree, Senator. I think it's a logical way to approach, and if we can actually save the expenditure of dollars on something that should not be the subject of expenditures, it'd be terrific if we can forestall that and use those funds more effectively in a different way.
Organizing this. My. What have our majority leader and the Democrats in the Senate wrought? They have overturned 227 years of precedents that my colleagues have talked about. 21 previous impeachments, all scheduled for trial. 17 came to trial, and the ones that did not, because the person who was to be impeached was either expelled or dismissed prior to the trial. To my colleague from Texas's point about the media being complicit, one of the headlines in Politico that I was told about said the trial lasted only 3 hours. There was no trial. There was no trial. The majority leader decided that he could determine what was unconstitutional and get every single one of his Democrats along partisan lines to vote for it. Said it was unconstitutional. Did not rise to the level of high crimes and misdemeanors. Let me briefly examine that. Article 1, sent over to us by the House. I'm just going to read the title. Willful and systematic or systematic refusal to comply with the law. That's Article 1. Let me tell you about complying with the law. Prior to this administration, the Trump administration had brought illegal crossings down to a 45-year low. What we have seen since then is an explosion of illegal crossings. Over 1.7 in the first year of the Biden administration, nearly 2.4 in the second, nearly 2.5 in the third. Now, if you count all the people who tried to cross the border illegal or have crossed the border, including the gotaways, it's 9.4 million people, larger than the population of New York City. 300,000 in just December alone. That is larger than our capital city, Nebraska, Lincoln. The evidence is right there that we're not doing a good job at the southern border. And why would that be? Well, because Alejandro Mayorkas is complicit in not following the law. In a memorandum Mayorkas sent to Immigration and Customs Enforcement officials in 2021, he said, and I'm going to quote here, "The fact an individual is a removable non-citizen," notice he doesn't even say illegal alien, which is what it says in the law. He says, "The fact that an individual is a removable non-citizen therefore should not alone be the basis for an enforcement action against them." Basically saying, just because you broke the law doesn't mean we have to enforce the law. That right there should tell you he is willfully disregarding the law. Absolutely. Or how about the case of parole, where the law says that it's only supposed to be used on a case-by-case basis in situations where the person has an extreme humanitarian need or it's in the best interest of our country. Under the Obama and the Trump administrations, it was used an average of 5,600 times, paroled 5,600 foreigners in this country between the Obama and Trump administrations on an annual basis. Last year alone, Mayorkas paroled into this country 1.2 million for whole classes of people. A clear abuse of the law. Folks, when you see instances where the Secretary for Homeland Security is not following the law, doesn't that raise the question, shouldn't we have a trial? Shouldn't we examine whether or not he actually should be convicted of this? And yet, as my colleagues have pointed out, not a single Democrat, partisan line, said no, that is not willful disregard of the law. Let's move on to Article 2. Article 2, again, I'm just going to read the title of this. Sent over, says, breach of public trust. Breach of public trust. Well, what does that mean? How about misleading Congress? Wouldn't that be a breach of public trust? On April 28, 2022, Mayorkas testified repeatedly in front of the House Judiciary Committee that DHS possessed the operational control of the southwest border, including in accordance with statutory definition. But I just told you how the number of people crossing the border had exploded. My colleague from Texas did a great job of talking about the human suffering this created. If we had been allowed to have a trial, we would have heard from Border Patrol agents who would have come up and testified personally that the border was not secure. I have been down to that border as well, 4 times. I've seen the people coming across. That border is not secure. In the last trip down there, it was mostly Hondurans, but it was a couple from Moldova on the Russian border that had paid to get across to our border because the whole world knows it's open. This is absolutely what we are talking about. That this is why we have to hear the evidence to go and determine whether or not there is guilt or innocence, and the Democrats have denied it, and it is to the detriment of our Constitution and our country that we are not being allowed to have a trial, to examine the evidence, and determine whether or not Alejandro Mayorkas is guilty and whether or not he should be impeached. I think the few things I have laid out here this afternoon go exactly to we should examine the questions. And the Democrats chose not to even ask the questions before they dismissed us entirely.
Senator Hawley.
Thank you, Mr. Chairman. Before I start, Mr. Chairman, I want to say thank you for your strong statement on the RICA legislation yesterday and for your leadership on this issue. It's much, much appreciated. Director Stone Manning, let me just start with this. When you came before this committee in 2021, this is before I was a member of the committee, you were asked as part of your confirmation whether you'd ever been investigated, arrested, charged by any federal, state, or local law enforcement authority for the violation of any federal, state, or local law, regulation, or ordinance other than a minor traffic offense. We asked that question of all people before the committee. You answered no. Do you stand by that testimony?
Senator, I do stand by that testimony and was proud to be confirmed to do this job.
What's tree spiking, Director?
Senator, again, this committee engaged quite a bit in
No, that's a factual question. Do you know what it is?
And I do. It is.
You want to tell us? Go ahead.
Yeah, it's when people illegally put metal objects into trees so that they prevent a timber sale.
What happens if a chainsaw hits a spike?
Sometimes when a chainsaw hits a spike, it can buck the saw.
Yeah, violently recoil, potentially kill or seriously maim the loggers.
Yeah, which is why I notified the federal authorities that I had heard that happened.
Loggers like, for instance, George Alexander, this is from an article on the Washington Post explaining what happens when trees get spiked. Loggers who are blue-collar workers, by the way, these are not wealthy people. These are not people who have had the advantages perhaps you and others have had. People like George Alexander, who, for example, in May 1987, at age 23, his chainsaw hit a tree spike. I'm quoting, his face was slashed from eye to chin, his teeth were smashed, his jaw was cut in half. That's a typical reaction when a logger hits a spike. Now, you just said, I think just a second ago, that you were involved. There were 2 people convicted in 1989 of putting 500 pounds of spikes in an Idaho forest. Senator Rich mentioned this just a moment ago. You testified you sent a letter to the Forest Service on their behalf. I have it here. The letter says, among other things, this letter sent to notify you that the post office sale, that's the forest sale in Idaho, has been spiked heavily. The reason for this action is that this piece of land is very special to the earth. It is home to the elk, deer, mountain lions, birds, and especially the trees. It goes on, I would be more than willing to pay you $1 for the sale, but you'd have to find me first, and that could be your worst nightmare. P.S. You bastards go in there anyway, and a lot of people could get hurt. Why'd you send this?
Senator, as I said at the time, over 30 years ago, a really angry and turns out violent person handed me that letter and said, will you send this to the Forest Service?
And you did. Why?
What you just talked about in 1987 to a logger, this is 1988, 9. I understood that people could get hurt.
Why didn't you notify the federal authorities? Why did you send this threatening letter on behalf of these 2 men who were convicted of crimes?
I was terrified of them and wanted no involvement with them.
So you wanted no involvement, but you sent a letter that says you bastards go in there anyway and a lot of people could get hurt? Why didn't you just contact the FBI or anybody, any local authority?
Because the person who did this act threatened people's lives if they disclosed who did it.
Yeah, in fact, you were investigated for being involved, weren't you? Here we have a letter sent to this committee from the special agent of the USDA Forest Service, Michael Merkley, who was in charge of the investigation. He says, and he details this in the letter to this committee, that he investigated you for your involvement. He says, and I'm going to quote now, grand jury subpoenas were issued for hair samples, handwriting exemplars, fingerprints. These subpoenas were served on persons suspected of being involved, having knowledge of the incident, including Ms. Tracy Stone Manning. You've testified you were never investigated, ever for anything. Why'd you lie to this committee?
Senator, this committee delved deeply, went into the court records where I testified against these men.
Were you issued subpoenas?
No.
You were not issued subpoenas?
I was issued a subpoena to appear before a grand jury with
Really?
with
Because
about 13
here's what he
people.
says. Ms. Stone Manning was extremely difficult to work with. She was antagonistic. She was uncooperative, refused to provide her handwriting exemplars and fingerprints as ordered by the grand jury. It was not until after we informed her she would be arrested if she did not comply with the subpoenas that she provided the samples to me. So you were subpoenaed.
Senator Hawley,
you
your
were
time
the
is
target of an
expired.
investigation.
Do you have a question?
You were the target of an investigation. You lied to this committee. Why?
Senator, I never received a target letter. I'm curious, I understand why this committee jumped over 30 years of my career in considering my nomination and went to a salacious moment from graduate school where I tried to protect people. What I don't understand is why we're not looking at the last 3.5 years now.
Here's why.
Senator
It's because people are killed in these kind of incidents. It is an act of
Your
terrorism.
time is expired.
A special agent in charge found that you were involved. You lied to this committee in saying that you were never investigated.
Senator
you were never
Hawley.
the target of investigation. In fact, you were.
Your time
You lied to us
is
blatantly.
expired.
And you know it.
Senator Brasso.
Thank you, Mr. Chair. Ms. Stoneman, the Bureau's Rock Springs Resource Management Plan will devastate the people of Southwest Wyoming, lock up millions of acres of land, local communities. The entire state relies on those lands. The governor, state legislature, county commissioners, local communities all strongly oppose this plan. So why are you ignoring Wyoming's opposition to the plan across the board?
Senator, thanks for the question. As you know, the Rock Springs plan there's a draft out. There was a public comment period. There was a lot of hyperbole about facts that were not true about the plan. So we've done a lot of education work with your constituents about what's in the plan. More importantly, we extended the public comment period and worked with the governor. He stood up a task force, and those folks got to walk in the shoes of our BLM field staff in Rock Springs to give us recommendations for the final. We're digging in, looking at those recommendations, and I am certain that Wyomingites will see their voices reflected in the final.
Well, I just hope the BLM does not dig in, but actually reverses course on this issue. Last month, the Bureau took steps to prohibit coal leasing in the Powder River Basin. The Bureau claims that coal production in the region won't be impacted until the year 2038, so 14 years from now. The Bureau claims that existing leases are sufficient to meet expected demand for coal. My question then is, why is the Bureau taking this action now if you don't say it's going to have any impact for at least 14 years?
Senator, thanks for the question. As you know, the President has asked us to turn and transition to a clean energy economy. The lands in the Powder River Basin are leased through 2041. And so you see the draft or the final before you. The record of decision is still in formulation.
Well, I'd point out that a front page story in the New York Times not too long ago pointed out that this president's pipe dream is not actually something that can be possibly done in our country and our needs for energy, as the committee hearings have shown again and again and again. I think this plan is completely reckless. Last year, the Powder River Basin supplied 45% of all the coal mined in the United States, and if this carbon-free grid doesn't materialize, and I don't believe it will, what do? You suggest that we start importing coal from China and other places?
Senator, I have great faith in the ingenuity of the American people. We are hard at work every day. We have permitted 7.9 gigawatts in just 3.5 years. I believe we can reach the transition the President has asked us to reach.
Well, I agree that the ingenuity of the American people, it's really hard when your agency continues to block efforts to produce the critical minerals that we need and so much of the product that we need for the American economy. So in April, your Bureau issued a rule that will dramatically raise bonding requirements on oil and gas producers. This is money that producers must pay up front in order to operate on federal lands. According to the data from your own department, there were only 37 abandoned wells on lands managed by the Bureau. That's less than 0.1% of all the wells that the Bureau manages. So how do you justify your decision to increase bonding requirements by as much as 25-fold?
Senator, both the Government Accountability Office and the Inspector General have written reports that suggest, I think rightly so, that our bonding rates, which are over 60 years old, are not high enough. We have thousands of idled wells on our public lands. And idled wells are the last stop before they become orphaned. Not all of them become orphaned, but the GAO found that thousands of them will.
Yeah, well, I don't buy it. This rule to me is completely arbitrary, it's punitive, and you're trying to drive oil and gas producers off federal land. I think it's disgraceful. Finally, in my remaining time, Wyoming is home to the large population of greater sage grouse and its habitat. For over 15 years, with Republican governors, Democrat governors working together, Wyoming has been at the forefront of adopting new management approaches to protect the species. Instead of working with Wyoming, your Bureau plans to upend the state's successful efforts at balancing conservation with economic development. Why are you ignoring a state that has proven time and again that it can successfully protect the species?
Senator, respectfully, I have a different view on our work with your state. We've been meeting twice weekly with the state of Wyoming as we develop the sage grouse plans. The only way to make these plans work is to work together with our partners in the states, and we have been doing so, and Wyoming has been helping us lead the way with the Sage Grouse Task Force at WGA. We are literally line editing the documents together, so I believe that they are going to have the durability that they need for success for the sage grouse.
Yeah, John Kennedy spoke at the University of Wyoming in 1963, and it was part of his tour of conservation in the West. And he said, we need to maintain a living balance between man's actions and nature's reactions. I have a picture of him giving that speech. Tom Udall's dad, who was Secretary of Interior, was with him that day in Wyoming, and it just seems that the BLM has gone a long way away from maintaining a living balance and basically trying to shut down the state of Wyoming. Thank you, Mr. Chairman.
Ranking Member Brasso.
Thank you, Mr. Chairman. Mr. Stoneman, the Bureau has yet to issue leases to the winning bidders of the December 2020 oil and gas leases. So it's now 2024, 2020 to 2024. When do you plan to issue the leases?
Senator, thank you for that question. We are still working our way through multiple court decisions. When we issue them, we want them to be durable and stick.
Because, you know, the law requires you issue the leases within 60 days, and it's now been over 3.5 years. So when do you plan, give me a date, when you plan to issue these leases that by law should have been released?
Senator, I don't have a date for you at this time.
Okay. 3.5 years, long time. Again, we need a date. Next, in June of 2022, the Bureau settled a lawsuit related to oil and gas leases that it had issued between 2015 and 2020 in Wyoming. In that settlement, the Bureau agreed to update the environmental analysis of the leases. So the Bureau's Wyoming office, the state office in Wyoming of the Bureau of Land Management, says they finished updating exactly what you wanted last summer. Finished what you asked for last summer. So why is your Bureau not then released this updated analysis?
Senator, again, as I was mentioning, we are reconciling different court decisions and opinions throughout the West, and we want to make sure that we are consistent.
Well, it seems like a lot of foot dragging. The state officers can't issue the permits to drill on these leases, refuses to until the Bureau releases the updated analysis, which was now done which was done a year ago. So again, when will the Bureau release that analysis?
I'm sorry, which analysis?
The one that was done a year ago by the Bureau, Wyoming's Bureau of Land Management, based on the 2022 settlement.
Yeah, again, Senator, I don't have a date for you.
Yeah, well, we need a date. And you can see how every member of this side says this is a deliberate sabotage of American energy by an administration with this approach, which is a pipe dream about their view of when we can get to a carbon-free America. And as our hearing showed last week, Mr. Chairman, China's beaten us to this because they're putting all the energy into AI, and that puts us at a competitive world disadvantage. Final question, so we're trying to keep this under 3 minutes. So last weekend, I was at the Wyoming Stock Growers Summer Convention in Douglas. A number of folks expressed concern about the process by which your Bureau considers public comments. Does the Bureau require individuals who submit public comments to identify who they are and where they are from?
Senator, I believe that is the case. And if I could revisit your last question, I don't think it's sabotage to be at record production highs for oil. and to issue 11,000 APDs.
It's a sabotage of public land use of the multiple use of the lands on public land. Well, so this is the question, getting with the question at front right now. So someone from a country like China or Russia or a computer which doesn't want us to develop our energy or our mineral resources, are they allowed to submit public comments? Is that correct? Because that's what we're hearing. The answer is yes.
Yeah, I assume they are.
It is, yeah. So they, can the Bureau even determine then whether a comment has submitted by a human or by a machine? The answer is no, you can't. In light of all this, shouldn't the Bureau give the most weight to comments from the people and the communities who actually live, as my friend and colleague just said of what's happening in Idaho and what's happening, who actually live and most affected by the proposals?
You might have suggested that your colleague has bots putting in comments. I don't think that's true. We read the comments very thoroughly. I think that we can tell when it's a bot and when it's a Russian and when it's an actual Idahoan, as the case is with what we got from the lava project. I don't understand what you're getting at, Senator.
We're getting at the fact that it seems that the comments coming in and are being counted as equal are those that have been in the land for 5 generations and those coming from communist China. Thank you, Mr. Chairman.
Senator Lee.
The Conservation and Landscape Health Rule that you recently finalized elevates non-use either on par with or arguably above multiple use. Now, according to FLPMA, BLM is required to manage for multiple use and for sustained yield, with multiple use referring to things like grazing, timber harvesting, energy, mining, and recreation. Can you cite a provision of FLPMA that allows for you to depart from that standard and to prioritize non-use instead of multiple use and sustained yield? What provision of FLPMA allows you to do that?
Title I, Section 103 is where the multiple use definition occurs in FLPMA, and it is very explicitly clear that managing for fish and wildlife habitat, managing for natural and scenic values, those are direct words from FLPMA, is our responsibility. And
yeah, look, I understand that, and that's as part of the sort of the recreation portfolio, and you've got the ability to do that. I don't think there's anything in there though that authorizes you to do exactly what you're doing here, which really is for deliberate, long-term non-use. This is a frustration that I have, and it's not just me that has it. I hear every day, all the time, from constituents, from local officials, who are increasingly frustrated at the direction that BLM has taken under your lead. Now, keep in mind, the federal government owns 67% of the land in my state, and the biggest share of that is Bureau of Land Management. And so we live as subjects to the Bureau of Land Management. And increasingly, BLM under your leadership seems to have taken an approach that manages these lands like a museum. It's a you can look but you cannot touch sort of approach. These are in people's backyards. You can hardly throw a rock in any direction in Utah and not hit federal land. Now, that portion of the land in my state, the portion of the 67% of the land in my state owned by the federal government, your portion of it amounts to 22 million acres in Utah. That's 7 million acres more than all of the land, not just the federal land, but all the land in the state of West Virginia. And month after month, a sweeping new policy or management plan seems to be imposed by your agency, harming Utahns who rely on the land for their livelihood, who rely on the land for all sorts of things. Now, the agency has strayed pretty far from its statutory mandate to manage this land for multiple use and sustained yield. The conservation rule is a pretty blatant example of this museum approach of you can look but you can't touch, one that's taken over the BLM. And I don't think it can be fairly reconciled with FLPMA. Now, Neda Wolf-Culver currently serves as the Director of Policy and Programs at BLM. And as you know, Ms. Culver previously worked as Senior Counsel and Director of the BLM Action Center at the Wilderness Society. While in that position, Ms. Culver was personally involved in advocacy and litigation regarding travel management planning and route closures in Utah. And in fact, Ms. Culver helped negotiate the settlement agreement a few years ago between various environmental NGOs and the Obama administration that established the process and the timelines for updating Utah travel management plans. Last fall, BLM closed 317 miles of historic roads in Utah as part of the update to the Labyrinth, RIMS, Gemini Bridges travel management plan. Director Stone Manning, Ms. Culver reports to you in her current role as Deputy Director. So I'd like a yes or no answer on this. Did Ms. Culver have any involvement in the decision-making for the Labyrinth RIMS plan?
Principal Deputy Director Culver does report to me, and the Labyrinth Travel Management Plan decision came from the ground where it should come from. And it was a part of a legal settlement. We got sued and...
No, I get that, but that's not my question. My question is whether she herself had any involvement in that.
Senator, decisions like that sometimes come to headquarters for review. I don't know if that particular plan came for review or not.
Okay, so look, she either recused herself from that decision or she didn't. Which is it?
Senator, she worked for the Wilderness Society and was wildly competent in that job.
Oh, I don't doubt that.
7 or 8.
That is not the subject of my question. What I want to know is, was she or was she not involved in that?
She does not have to recuse herself from the Wilderness Society. She is out of the recusal period.
Okay, so you're saying that it's okay for someone with a history of advocacy and litigation on these routes, not just routes like these, but on these specific routes. She was involved in litigation as an advocate specifically on these routes. Her name, I believe, is on the settlement, the consent decree documents that resulted in this process. Saying that it's okay for her to do this and that she can impartially oversee the BLM's travel management planning in that area.
Senator, we adhere to high ethical standards at the department, and we've done so here.
All right.
Senator.
Can I ask one follow-up? I'll be quick.
Very quickly, please.
All right, look, your updated Western Solar Plan expands solar development on public lands. How are you going to ensure that the expansion doesn't disproportionately limit other critical land uses, things like recreation and wildlife conservation and grazing?
Yeah, Senator, you've hit the nail on the head on what we do every day, right, is balance all of those uses. And the Western Solar Plan is going to help us guide solar development to places so that those decisions become more durable. So we've got this programmatic look at where development should go so that when we do the individual NEPA analysis, it becomes more durable.
Senator Hawley?
Thank you, Mr. Chairman. Congratulations to all of the nominees. Judge Ali Khan, I think the last time you and I visited, it was before the Homeland Security Committee. And I asked you a number of questions there, you, including some for the record, you answered those, which I appreciated. One question that I ask you, and I ask every nominee actually on that committee and this one, is whether or not the nominee has ever litigated against a religious liberty claim. Usually the answer to that's no. In your case, you answered yes, and you listed 1, 2, 3, 4, 5 different cases over a period of years actually in which you have litigated against individuals or churches' religious liberty claims. So let's just talk about a few of those if we could. Let's start with some of your work during COVID. Case you list here, Capitol Hill Baptist Church versus Bowser. Do you remember that case?
Yes, Senator.
You remember working on that case?
Yes, Senator.
This was a case involving the district's lockdown policies that shut down churches in the district. Is that correct?
It concerned litigation over provision of the lockdown policies. The policies restricted all types of activity in the district.
All types of activity in the district?
Yes, Senator.
Did it restrict mass protests in the district?
Well, it restricted activities that one normally expected, including work, going to stores. It also did include these provisions that were challenged concerning churches.
So it exempted unusual or unlikely activities that's in the statute, that's in the ordinance?
When the mayor was enacting these orders at the outset of the pandemic, I think she was trying to be as comprehensive as she could, and the order did restrict a number of daily activities of district residents.
But it exempted mass protests?
I don't believe it said anything one way or another.
Can you point me to the text where it exempted mass protests?
I don't believe it said anything one way or another.
Of course it didn't, because it didn't exempt mass protests, right? You know that.
I think it was silent on the issue because I don't believe it was contemplated by the mayor's office.
Ah, so you think that mass protests should be in a different category than religious observances? Is that your position?
I think if there were protests on the book, then the mayor might have thought about that when she was enacting the COVID-19 restrictions. But I think she was trying to protect public health.
So you think it's fine to say to religious people that they are prohibited from gathering outside, wearing a mask, socially distanced. They can't do it. But if you want to come and protest, defund the police, if you want to support that, that's fine. You can gather en masse, person to person, close up, thousands of people. That's okay. That discrimination's okay. That is your position?
Senator, that is not my position.
It was your position. It's what you argued.
I did not write these orders. What I said.
You defended it in court. And you just articulated to me what I take to be your position.
What I was doing in the Capitol Hill Baptist Church was defending the mayor, my client, against a constitutional challenge to one aspect of the COVID-19 restrictions. We understood that strict scrutiny applies.
How did that case go for you?
We lost that case.
Why?
It was found that the restrictions did not meet the standard of strict scrutiny.
Meaning they were unconstitutional.
Meaning that they did not survive strict scrutiny. And it's a matter of public record that the District of Columbia did not appeal that decision.
Why? Why were they struck down?
Excuse me, Senator?
Why were the restrictions that you defended struck down as discriminatory? Why were they?
Because they did not satisfy.
Why didn't they?
The court concluded that there were restrictions that were not neutral of general applicability.
Yeah. That's legalese. Why didn't they? Why didn't they on the facts? You know the facts. You were a good lawyer. Why'd you lose?
We lost because applying the strict scrutiny test, the court concluded that the restrictions were not narrowly tailored to serve a compelling governmental interest.
Because?
Senator.
Oh, come on, Judge. Don't make me do this. Do you want me to go through it for you? You lost because Mayor Bowser was going to mass protests herself personally with thousands of people celebrating them. By the way, which is fine. We have the First Amendment in the United States. I want to be clear. That is totally fine. You want to protest? Go for it. I think that's totally fine. That wasn't the problem here. At the same time she was doing that, she was prohibiting churches, religious people, from gathering socially distanced outside wearing masks. And the district court said, you can't do that. That's discrimination. You can't separate people out based on their ideological beliefs or their positions. You can't do that, right? Isn't that what the district court said?
The district court said that
do you agree with it?
Could not survive strict scrutiny.
For those reasons, right? Why are you fighting me on this? I can't figure this out.
I am not fighting you, Senator.
So yes, you agree. That's what the district court said.
That was what the district court concluded.
Do you think they got it right? The district court get it right?
The district court, we did not appeal that decision. I think that district court decision is consistent with rulings that we got from the Supreme Court clarifying the application of the religious test to COVID-19 restrictions in Tandon and the Brooklyn Archdiocese.
My time's almost expired, and I know other senators want to ask questions, so let me just very quickly here. Do you think it's wrong to discriminate on the basis of religious faith?
Absolutely, Senator.
Why did you argue that religious services, religious people pose a greater risk of infection than people gathered to argue for defunding the police?
I was representing my client. The mayor and consulting epidemiologists had issued orders that she thought were going to protect public health. It was my role to defend those as a
Why did you make that argument? This seems like a strange argument to me, that religious people are somehow, more infectious than folks who have other ideological positions? I don't get it.
My understanding was the nature of singing and other things epidemiologists thought could transmit COVID at a higher rate.
You didn't put any scientific evidence in the record for it?
Senator, those were fast-moving cases, and they weren't going to full briefing and full summary judgment with a record.
That's not what the district court said. The district court said that you engaged in, and your client engaged in, and you defended discrimination on the basis of religious belief, that you offered no scientific evidence for it, that you pressed these arguments over and over and over without any foundation. Frankly, I'm disappointed that you made those arguments. You can choose what arguments to make. I'm disappointed you made those arguments. I'm disappointed you persisted in defending them here today. And for that reason, among others, I will not support your nomination. Thank you, Mr. Chairman.
Judge Ali Khan, am I saying that right?
Yes, Senator.
Okay. Will you allow your personal or political beliefs to affect your decisions?
No, Senator. My personal beliefs have never played a role in the positions I took as an advocate, nor do they play a role in the positions I take as a judge when I'm neutrally deciding a case.
Okay, I'm glad we got that off the table. Let me ask you a few questions about how you view the world. Do you believe that minorities need special help to succeed?
Senator, that issue is currently pending before the U.S. Supreme Court.
Yes, ma'am, but we just established that you're not going to let your personal opinions affect your decisions. You're going to follow precedent.
Absolutely, I will follow whatever
Okay.
precedent comes
So let's
from the
talk
Supreme
about your
Court.
personal opinions, which will be irrelevant to your position on the court. Do you believe that minorities need special help to succeed?
Senator, again, I don't have a personal position, and sitting here as a current sitting judge and
Have you
as
thought
a
about
nominee,
that? Have you thought about that?
I am aware that we have given preferential treatment. It's been subject to a lot of different court cases. The
Okay, do you
issue,
agree with that or disagree with it?
it's not a question, Senator, of whether I agree or disagree. I
Sure it
apply the
is.
law
You're-
as it comes before me.
You're being confirmed to the federal bench, and presumably you're a critically thinking person. I'm just asking you what you believe. Let me ask you one more time. Do you believe that minorities in America need special help to succeed? It's a very simple question.
Senator, to the extent policymakers have enacted laws that provide protections,
Do
I
you
would
agree with
faithfully-
those policymakers?
I am not a policymaker, and as a sitting judge, it is...
You don't have an opinion, or you're just not going to answer. I don't want to waste more time if you're not going to answer.
Senator, as a sitting judge, it is inappropriate for me to
No, it's
comment
not.
on my personal views.
No, it's not. We've already established that you're not going to let your personal beliefs interfere with your decisions, so I think you ought to tell us what your personal beliefs are. Do you believe do you believe in systemic racism?
Senator, again, that's a question for sociologists and academics. I take
You
every
don't have an
case.
opinion. You never thought about it.
I take each case as it comes before me on the individual facts.
What is systemic racism?
My understanding is that it's a sociological theory that racism plays a systemic role. But beyond that, I'm not an academic. I'm not a sociologist. I am a judge, and I apply the facts and the law to the cases that come before me.
Right, but you don't have an opinion.
No, Senator, I do not.
Do you have an opinion on anything you'd like to share with us?
Senator, as a sitting judge, it's inappropriate for me to comment on any personal views I might
No, it's
hold
not. We
because
just
I would not.
established, the first question I asked you was, your view of the world does matter. If you never thought about the world, if you never thought about these issues, you're not qualified to be a federal judge. And I think you ought to come here and answer. I think all of you should come here and answer them forthrightly. If I ask you, let me ask you one last question, and I will quickly, Mr. Chairman. Do you believe, you sit on the District of Columbia Court of Appeals. Is the District of Columbia Court of Appeals systemically racist?
Senator, as a sitting judge, I think it would be inappropriate for me to comment. I can say all of my colleagues take the cases open-mindedly
But do
and
you
on the
think it's
facts that before them.
systemically racist?
I don't think that it is, Senator, but I also
Okay.
don't know if I'm qualified to give that type of assessment.
Well, you sit on the court, right?
I think all of my colleagues take their cases with an open mind, without any prejudice, and faithfully apply the law to the
Well, I'm
facts.
disappointed you won't answer my questions, but I thank the chairman for giving me the extra time.
Senator Lee.
Thank you very much, Mr. Chairman. Thanks to all of you for being here. Judge Ali Khan, I'd like to start with you. Tell me in one sentence what a judicial philosophy is. What do you think that means?
I think it's the set of principles that a judge brings with them when they join the bench.
How would you describe yours?
My judicial philosophy has three components, Senator. First, the humility to understand that the judicial role is quite limited. Legislatures enact laws, executives enforce them, but the only role of a judge is to apply the law to the facts of the case before them. Second, to make sure that all parties leave my courtroom feeling like they have been heard, knowing they have been respected, understanding that I have been well prepared and asked good questions. And finally, that I issue opinions that are prompt yet thorough and that are written in such a way that both litigants and pro se parties can understand.
What role should the text play when you're interpreting a provision of the U.S. Constitution or federal law?
The text is primary. You look at the text first. If it is unambiguous, that answers the question. That is well settled Supreme Court precedent.
Where there's ambiguity, what do you look to resolve the ambiguity?
So when there is ambiguity, for example, in a statute, you would look to not just the text, but the context. If there were, depending on when the statute was passed, looking at relevant dictionaries from the time to understand the public meaning of the words that were used. Also looking at the way those words are used in analogous statutes from the time. Ultimately, once you've exhausted text, context, history, dictionaries, you can look at canons of construction.
But the effort should involve trying to ascertain the meaning of those words at the time of enactment, if a statute, or at the time of ratification, if a part of the Constitution.
Yes, Senator. That's why you look to contemporaneous dictionary definitions.
Thank you. In 2021, you spoke on a panel at an event, I believe, honoring the 20th anniversary of the founding of the American Constitution Society. And in your remarks, you said, quote, "I've been able to think through my job, to carry out and live some of the values of ACS." Tell me, Judge, how did you carry out and live some of the values of ACS as Solicitor General and now as a judge on the D.C. Court of Appeals?
The values of ACS, as I understood them, were education and mentorship, and I try to carry those out both in my role as an advocate and now as a judge to make sure that I'm speaking to the next generation of lawyers, to make sure that I keep an open mind, stay current on interesting debates, stay current on the current state of the Supreme Court cases so that I can apply them faithfully to the cases that come before me.
Okay. And what other values might you refer to ACS? Are there others other than the ones you've just described?
I understand from Senator Blackburn there's a long mission statement for ACS. My involvement with ACS has always been on these types of panels where we're discussing legal issues, on mentorship events, when I'm speaking to the next generation of lawyers, particularly about opportunities in public service. And then oftentimes ACS and the Federalist Society will pair up at law schools to have different issues sort of aired and debated. I loved going to those events when I was in law school, and I love speaking at those joint events because I think you're really getting a way of understanding the diverse perspectives of the law. I think that makes us all better students of the law. Obviously, as a judge, my role is just to look at the law and the facts and the cases that come before me. But for those that are still in law school, those that are exploring careers in academia and policy, I think these are interesting debates to be having.
Judge Alicant, I want to come to you. Some remarks you made when you were Solicitor General in D.C. to the American Constitution Society event. And you said, and I'm going to quote you through this, that it was in your job you try to carry out and live some of the values of ACS. And here's a portion of the mission statement for ACS, and this is off of their website. It states that ACS mission includes redressing the founding failures of our Constitution and enduring inequities in our laws in pursuit of realized equality. So, in your role as both an advocate and now as a judge, do you subscribe to that part of the mission statement, and what do you see as the enduring inequities in the laws that need to be redressed?
Senator, when I said as Solicitor General that I carry out the values of ACS, it was the values of mentorship and discussion and vibrant discussion and debate.
So then you don't agree with what is on their website? So here's another part for you. It also notes on their website that its goal is to promote laws and policies that advance realized equality. So what laws and policy are you trying to promote? And then is this part of what you're trying to carry out? Is it activism as a judge that you're seeking? So as a federal judge, what would that look like if you're trying to live this out, if you're trying to carry it out, if you're trying to change those laws?
Senator, as a judge, it is not the role to change laws. It is to interpret and apply the laws that this body passes.
Okay, well, in your comments, that's what you said. I'm quoting you, back to you. So how would you advance realized equality from the bench?
Senator, In my current role, I take the law and I apply it to the facts and cases before me. That is what I would do if I were fortunate enough to be confirmed.
Okay, so how would you fulfill your duty to neutrally apply the law of people that are coming before you? So describe to me your method of statutory or constitutional interpretation. How would you carry that out?
Absolutely, Senator. When I am confronted with a statutory or constitutional interpretation case, I take my cues from the Supreme Court. The Supreme Court has instructed in statutory interpretation cases, you first must look at the text, and if the text is unambiguous...
Okay, so what is your understanding of original public meaning?
My understanding of original public meaning is that it is a tool of constitutional interpretation that the Supreme Court has used in interpreting the Second Amendment and the Confrontation Clause, and I would faithfully apply the Supreme Court's mechanisms for interpreting.
Original public meaning seeks an understanding of the statute as it would have been understood by the general public at the time of passage. Okay, let me move on with you for something else. Your previous nominations process, you answered several questions for the record indicating your views on when nationwide injunctions are appropriate. So can you point to any provision of the Constitution or federal law that expressly permits a single district judge to grant relief that is binding on the entire nation? Give me one.
The All Writs Act and Rule 65 and judicial precedents do not foreclose a district judge from entering relief that is beyond the geographical boundaries, but it should be, and as an all injunctive relief, sparingly used because it's a drastic remedy.
But it is appropriate that neither the Constitution nor any federal statute explicitly authorizes district judges to issue nationwide injunctions. Isn't that correct?
Thank you, Senator Johnson. Senator Hawley, you're recognized for your questions.
Thank you very much, Mr. Chairman. Dr. Shogan, when you were here last year, a number of senators asked you, including me, a series of questions about articles you'd written, public statements you had made on social media that were, I have to say, pretty grossly partisan, and I thought offensive, and you and I went back and forth about it. After that, a number of us asked you questions for the record relating to these statements. I want to follow up on one of them. I, in particular, asked you to give us a full accounting of the public posts that you had made on Twitter. You had locked your Twitter account before you came before this committee. It had previously been public. I asked you to provide the public posts that had previously been available on Twitter because the ones that we have were pretty disturbing. You responded as follows, and I quote, "My personal Twitter account is comprised of posts about my mystery novels, events at the White House Historical Association, Pittsburgh sports teams, travels, and my dog," end quote. Is this an accurate statement?
Yes, Senator.
I just remind you, you're under oath. Is this an accurate statement?
Yes, Senator.
Well, let's talk a little bit about your Twitter posts then that I was asking you about. On February 18th, 2022, you posted on Twitter bemoaning the dropping of mask requirements for children, including those under the age of 5. Do you remember that post?
No, Senator. Those tweets were in my personal capacity.
No. I asked you, would you give all public posts that you had made on Twitter? You said no, effectively, and you said that your Twitter posts consisted of mystery novels, events at the White House Historical Association, Pittsburgh sports teams, travels, and my dog. And you just told me now under oath that you stood by that. So now let's talk about your Twitter posts. On February 18th, 2022, you posted bemoaning the fact that mask requirements for children under the age of 5, one of whom I happen to have, by the way, had been dropped. Is that a post about your dog or sports teams?
My social media is in my personal capacity,
Answer
Senator.
my question, please, because you've testified under oath that you only posted about your dog and sports teams and novels, and you also said you wouldn't give this committee any of your public posts. So, is your post on February 18th, 2022, bemoaning the lifting of mask requirements for children under the age of 5, who I might just ask all of the data has said is extremely harmful to children, these mask requirements? We'll leave that aside for now. Is that a post about your dog or sports teams? Yes or no?
My social media is in my personal capacity, Senator.
Yes or no, Ms. Shogan? You are under oath before this committee, and I have to say, you have placed this issue squarely in record by repeatedly refusing to answer. Yes or no?
My social media is in my personal capacity, Senator.
So you're not answering my question. Let's talk about another post. 26th of May, 2022, you talk about an assault weapons ban. Retweet a post, ban assault weapons now. Say you agree with this idea that you have to be a certain age to buy so-called assault weapons in America. Is that a post about sports teams or your dog or mystery novels?
My social media is in my personal capacity, Senator.
What about the post on January 5th of 2021 in which you say that Ted Cruz ought to stay in his own lane and not worry about what's going on in Pittsburgh? This is a reference, I think, to questions he had about the certification of the last election. Is that a post about your dog or sports teams or mystery novels?
My social media is in my personal capacity, Senator.
What about the post, you remember December 10th, 2020, where you said that you were hoping that President Trump would have his vetoes overridden, and you agreed with the post that he was a weak policy president? Is that a post about your dog or sports teams or mystery novels?
My social media is in my personal capacity.
What about your post on January 5th, 2021, in which you speculated that President Trump would pardon himself next, participating in a conversation about the certification of the Electoral College? Is that a post about sports teams or mystery novels or your work at the White House Historical Association?
My social media is in my personal capacity, Senator.
What about the post? Do you remember this one? I said we seem to be having an incredible case of amnesia, but maybe you remember this one. This is from December 3rd of 2021, in which you advise an individual who goes by Meg on social media that the Library of Congress, you advise this person to complain about religious flags that have been planted on the grounds of the Library of Congress, and you say that they ought to be removed. And you go on to give this person advice about how to complain and have them removed. Do you remember that post?
My social media is in my personal capacity.
Do you remember the post?
My social media is in my personal capacity, Senator.
I have to say, I have been here for 4 years in the Senate. I have never seen a witness stonewall like this before. Never. And I've seen a lot. This is extraordinary. Do you remember this post? December 3rd, 2021.
My social media is in my personal capacity, Senator.
I mean, this is unbelievable. And you want to be the archivist of the United States. You lied to us under oath. You lied to us in your QFRs. You just lied to me a second ago under oath. And now you're sitting here stonewalling, not answering questions about public posts that you've made. Are you a lawyer, Ms. Shogan?
No, Senator.
Are you familiar with the Shirtliff case at the United States Supreme Court?
No, Senator, I'm not.
Well, in that case, the Supreme Court held that, in fact, it constitutes viewpoint discrimination for a government entity to remove religious flags from its property when it's opened up the property to allow other people to put flags on it. Exactly the question that you were addressing in your public posts on Twitter. You're giving legal advice, which you're not qualified to give, directly contrary to the United States Supreme Court. I just wonder, does this have to do with your view that you wrote about that the religious right is connected to the rise of anti-intellectualism in American politics? Is that why you said what you said about religious flags, that the religious right is a force for anti-intellectualism? Explain that to me.
No, Senator.
Do you stand by your comment that the religious right is part of the rise of anti-intellectualism in American politics?
Senator, that article was written. It was about how Republican presidents use common sense terminology to effectively communicate with Americans.
Yeah, in which you said that the religious right, the rise of the religious right is part of the rise of anti-intellectualism in American politics. I just point out that's the article in which you say anti-intellectual, the title is Anti-Intellectualism in the Modern Presidency, Republican Populism. Very nonpartisan. Dr. Shogan, I'm going to ask you again, will you give to this committee your public posts on Twitter? Will you make them available to this committee?
My social media is in my personal capacity.
Mr. Chairman, I have to tell you, this is the most extraordinary thing I have seen in my brief time in the Senate. I have never seen a witness blatantly lie under oath like Dr. Shogan has just done to this committee, stonewalled this committee, and just repeatedly refused to answer my questions about her own posts that are in public. For these reasons, I will oppose your nomination, and I strongly, strongly urge this committee to take action on this and force this witness to own up to the fact that she is misleading us right now before our eyes, Mr. Chairman. Before we vote on this nomination, I just want to express my deep reservations with this nominee and explain why I will be voting no, and appeal to my colleagues across the aisle to join me in trying to get relevant documents from this nominee from the Congressional Research Service. This is a nominee who was before the committee last September, I believe it was. We have a pattern from this nominee of stonewalling this committee, misleading this committee, and now she's doing the same with, frankly, very disturbing whistleblower accusations that came to us at the end of last week. I'm sorry, I think it's been almost 2 weeks ago now. Let me just refresh here the record. In September of last year, when the nominee first came before the committee, Senator Portman asked her a series of questions about her statements made on Twitter. Senator Portman's staff had found these statements themselves. She had locked her Twitter account at some point when she was in the nomination process. They found her Twitter statements, which were highly partisan, I think highly inappropriate. She refused to answer Senator Portman's statements at the time, questions at the time. So I introduced a question for the record asking her to please give to us any Twitter statements she had ever made that had been available to the public. She refused, and she then said, do we have that board, guys? She then said the following in response to my question for the record. She said, my personal Twitter account is comprised of posts about my mystery novels, of which she's written several, events at the White House Historical Association, Pittsburgh sports teams, travels, and my dog. It was made private months ago before I was nominated as archivist. Now, we know from the Twitter post that Senator Portman found this is simply not true. It is not true that her posts are composed of comments about her mystery novels and so on and so forth. We know that they are composed of highly partisan statements. When I asked her about this, I gave her a chance to correct this testimony. She said she stood by it. I then asked her, I went post by post, where she criticizes former President Trump, where she criticizes members of the United States Senate, where she expresses highly partisan views, where she suggests that religious groups should not be able to put up religious symbols on federal property, which is, by the way, not in accordance with the Supreme Court case law. And in all of these, she then refused to answer my questions. Now listen, she's entitled to have her views. She can say whatever she wants, and she can say whatever she wants on Twitter. But what she cannot do is lie to this committee. And to say to this committee that her post consisted of this, when we know from Senator Portman's research that's not true, is simply false. That's point number one. Thank you, Vijay. Point number two is after that testimony, a whistleblower, former employee of Dr. Shogan, came forward to my office. We have a normal whistleblower procedure. I'm sure you all do. We followed that procedure. I think she came to us on a Friday. We sat down with her as quickly as we could, following our usual procedure. I then called the chairman about this, and we're going to refer her allegations, I'm saying her because she's allowed her identity to be used, to the committee, which we did. The committee staff had an opportunity to meet with her. I understand they did again yesterday. And I will just tell you, and I know you all are aware of this because I've sent you all my letter that references the allegations that were made. The whistleblower said that when Dr. Shogan was at CRS, she engaged in partisan conduct and abusive behavior, allegedly, that she allegedly made unsolicited statements of support for political candidates in the workplace, that she also attempted to organize signing events for her book on federal property during work hours for commercial gain. That's the book that features the killing of a Senator Langsford, yeah. Senator Langsford seems to be doing well, though, I'm happy to say. The whistleblower further alleges that Dr. Shogan engaged in a pattern of abuse, retaliation, and persecution, including undermining the whistleblower's promotion, and that Dr. Shogan failed to discipline subordinates who made racially derogatory remarks to the whistleblower. The whistleblower is a woman of color. Now, when the staff, as I understand, asked Dr. Shogan about this, she repeatedly said she couldn't recall, she didn't have documents, and she referred staff to CRS and said you should contact CRS to ask for promotion documents, to ask for documents about her workplace event with her book. So last night, I sent a letter to CRS asking for the relevant documents. And all I would say, drawing to a close now, Mr. Chairman, what I would say is I would humbly suggest and request that we postpone a final vote on this nominee until we get these documents that Dr. Shogan referenced but said she didn't have, she couldn't get us, and repeatedly referred us to CRS. So I've asked for them from CRS. I think we should get them and look at them and do our due diligence on these whistleblower allegations. That's all I have. Thank you, Mr. Chairman.